My question regards property that you may have had prior to a marriage. If when one person dies, what is Alabama's law on that, especially as it regards children of prior marriages?
You want to take a stab at that, James?
Yeah, I'm trying to understand your question. So you own some property, and then someone died. Who died? Who are you talking about?
No. You own, both parties own property. Then you all got married, second marriages, and then one person would die. What would be the division of property as far as prior children's claim, children from prior marriages claims, or anything like that?
I got it, and I better take that question because it's kind of convoluted to explain it to Jim. Thank you for calling, and we want to answer that question. So when you have a second marriage, and then you get and you have property from a prior marriage, anything that is brought into the marriage that is commingled, like you both live in a certain house, then it becomes marital property and subject to division. If one of those spouses dies, okay, and that each spouse has children from prior marriages, if you do not have a will, then the property of that person that died, of the spouse that died, then passes through intestate succession. So state law will govern how that property is passed to the heirs of the estate. If you're a married spouse with kids from a prior, the laws of intestate succession is half goes to the surviving spouse, and the other half is then divided among your bloodline children. And so in that case, that person's child would inherit half of the estate, while the surviving spouse would inherit the other half. Now, let's say that you both wanted your separate children to have your entire estate. We go right back to the prenup. If you have a situation where you have children from a prior marriage, those parents should get a prenuptial agreement that says if one of the persons dies, their estate is not divisible and can be willed through a will to their separate children, and that way the estates go to their respective estate goes to their separate children, if that's the way they want it done, or any other way they want to do it. So it's very important that if you do have children from a prior marriage and you're getting married a second or third time, a prenuptial agreement can dictate how you want that piece of the estate to be distributed, and also get a will and make it clear what your intention is.
Oh, I figured everything would just go to the spouse.
Negative. When there's children from a prior, it's 50% to the surviving spouse, and then the other half divided among their bloodline children, that deceased bloodline children.
Interesting.